First, let me recall why we are here. Beginning in 2019, Pacific leaders noted the proposal by our island youth at the University of South Pacific to bring the issue of climate change to the world's highest court. In 2022, our leaders in the communique of the 51st Pacific Islands Forum Leaders Meeting called on the United Nations General Assembly for a resolution requesting the International Court of Justice to provide an advisory opinion on the obligations of states under international law to protect the rights of present and future generations against the adverse impacts of climate change. This specific call became a reality when on 29th of March of this year, 132 co-sponsoring nations joined us to table our resolution at the UNGA. It is our hope that all Pacific nations will take part in all parts of the process, which will have transformative impact on the way states act to reduce emissions and address impacts of the climate crisis beyond their sovereign boundaries. And that is why we are here today. In total, we have the participation from Attorney General and legal office representatives from 16 Pacific Island countries and territories, including Cook Islands, Federated States of Micronesia, Fiji, French Polynesia, Kiribati, Republic of Marshall Islands, Nauru, New Caledonia, Palau, Papua New Guinea, Samoa, Solomon Islands, Tokelau, Tonga, Tuvalu, and Vanuatu. From pro bono legal experts, from external law firms to tailored science to financing for further domestic and regional rights shops, we have everything needed for us to progress. We benefited immensely from the expertise of international legal experts, including Professor Mamadou Hebi, who was Special Assistant to the President of the ICJ from 2018 to 2021, as well as Professor Hoe Binwales and our own Pacific legal experts, including Her Excellency Dame Meg Taylor. It is clear to us that many states have breached the existing international obligation and undertaken lawful actions related to greenhouse gas emissions, which have injured and harmed us in the Pacific and our people and individuals of present and future generations. Equally important, we have discussed the legal consequences of this unlawful conduct, which we expect the court to find will result in a duty of compliance with their primary obligation. Secondly, cessation of any ongoing violations, which is particularly urgent in the context of climate harm that is rapidly worsening and will require deep decarbonization and energy transition. Third, provide full reparation, which is a very clear consequence of breaching obligations as defined by law of state responsibility. To move us forward, Vanuatu provided template submissions which contains the structure and key legal content, which should help us all move forward in a consistent and rapid way, yet can be tailored to our own national context and legal priorities. Our sixth session welcomes civil society to join us as we develop our submissions, both as part of national writing teams and as providers of content to annex to our official submissions with real stories, observations, and evidence from grassroots communities. Excellencies, we must keep this planet below 1.5 degrees, as science so clearly demands. International law may be the last lever the Pacific has to pull that will motivate high-emitting states to reel in dangerous conduct, which is causing us existential crisis for our countries. This advisory opinion from the International Court of Justice will draw a clear line between what is an acceptable outcome of UNFCCC climate negotiations and what is a non-negotiable legal responsibility for all states. The past 3 days, we have gone through a lot of information. We've discussed a lot, shared a lot of information, and the team has come up with the outcomes document, which we'd like to share with you and to receive some comments. Just to recap the good work of Pacific delegations over the course of the 3-day rights shop, marking the beginning of work towards to the ICJ, and to help deliver an advisory opinion that ensures nature, communities, and the Pacific way thrives. Now, as we go back to our respective capitals, This is what we hope that we can work on in preparation for the deadline, which is the 30th of October. That is delegations will endeavor to secure a policy approval from government to engage with the ICJ advisory opinion process before the end of August 2023, to create a core list of issues and applications to help guide the development of submissions responsive to the question asked to the court in the General Assembly resolution. And third, to develop a joint and regional submission strategy, in addition to individual submissions by Pacific Island countries and territories. Fourth, to establish an informal working group with at least 2 government focal points from countries and territories, because when we go back to our capitals, it's very easy to get bogged down in domestic issues and forget about this. So it's important that we keep the momentum going. So that's why we just 2 government focal points from countries and territories participating to perform at least the following tasks. Prepare a document that tracks the status and needs of Pacific Island countries and territories in drafting process. That's example, the status of drafting, status of international legal representation, expertise and resources needs, and also to maintain a checklist of concrete actions needed and a corresponding time frame, so that joint regional and individual Pacific Island countries and territories submissions are completed by the deadline set out by the court. Again, you have a checklist of actions to do, as well as a time frame to complete it. And plan a follow-up Writeshop in the late September, early October to ensure strength and complementarity of submissions prior to the deadline. Now, while on that, just a show of hands, who thinks the follow-up Writeshop is important, just by indication of hands? All right, there we go. Thank you. Last, continue strategic discussions and convening meetings throughout the ICJ advisory opinion process. 5, create and maintain pathways for civil society input and expertise to be incorporated within joint regional and individual Pacific Island countries and territory submissions. Of course, we heard from Dr. Jan Frey, about their work on with respect to amicus curiae. Please, that's something we must seriously consider. 6, determine what role crop agencies will play in the process of coordinating submissions. And 7, engage with subject matter experts for the purposes of law, facts, and science. So basically, that's the outcomes document from the discussion we had in the past 3 days. And in line with this agreement, delegations recognize and celebrate this unprecedented and Pacific-led opportunity for a progressive and climate justice-focused advisory opinion. Climate action is not a mere matter of state discretion. It is an exacting requirement under international law that comes with enforceable consequences. Excellencies, to end these remarks, please allow me to again acknowledge the Pacific Island University students for their passion, courage, and wisdom to fight for this initiative that could change the world. Let me also acknowledge and thank the Human Rights and Social Development Division of SPC, who has played a key role in organizing this Writeshop with the financial support of the governments of the United States of America and Australia and Sweden. And colleagues, if we may, by showing our appreciation to SPC, please give them a round of applause.